so much. Looking forward to hearing your presentation.
Thank you very much. Well, all will be disappointment and downhill. No, great pleasure to be here. Thank you for that introduction. Thank you, Igor, for the invitation. And well, the start has been quite excellent. And I have to make a confession, because I'm as much a student of this subject as most of you people out there. I mean, I've had an interest in shipping and maritime matters, but I think it's a generation thing. You know, computers and software don't really attract me as they do the younger generation, and everybody here is member of the younger generation. So I have been reluctant, and I'm not too diligent and enthusiastic a member of the CMI. I enjoy the institution and its conferences. But I found myself on the International Working Group dealing with marine insurance, which, if I can say privately and on the basis that nobody quotes me, is just about the most inactive committee I've ever been a member of. But anyway, so it's not a burden, but I thought at some stage, because the CMI was also looking at mass, that we should possibly address the situation. So, and that's only a few months ago. So I then put a few thoughts together about mass, and I have learned enormously from the earlier sessions. So I compliment all the speakers, and I'm looking forward to everybody's session apart from my own, because it is a very acute learning process, and it's a delightful way to learn the subject and to see the topic. I say in passing, I mean, it might be more significant now, but in the UK, they've passed a law with regard to driverless cars. Right? And the basis of liability is on the manufacturer. Right? Statutory, so we don't have to go into any common law, sort of law kind of analysis, but a somewhat arbitrary situation. I would like to be able to give you more details, but I know that I don't have. But when I go back now, I'll check it a little further. It's a statute which is encouraging the manufacture and growth of electric cars, and it deals with the question of liability in an interesting way. Now, when I speak to you today, I'm going to speak more from the perspective of the insurance industry rather than the legal response to their instruments. So we'll look at some of the issues that exist, but it's as well. I mean, and if we actually are in tune with the way that insurers think and what is important to them, that will influence the way that we look upon insurance as an instrument which aids the legal process. So, and let's face it, insurance in commerce is of prime importance. Insurance makes the world what we have. I mean, and if insurance doesn't support mass, that's the end of the tale. Doesn't go any further. Because when you think about it, the ship can't actually move without insurance. They don't have to be, flag state, the port state control, all manner of requirements. And of course, people are going to be aware of that with regard to our area, because our ship owner, when he's buying products in, will be looking not only to the product, but increasingly he might say, are you insured? So they will have insurance guarantees in their supply contracts to make sure that that linkage, because the last thing you want is to have a recourse action to find they're not insured or whatever. So that's the position. Justin and our chairman gave us a nice introduction to insurance and its dimensions in shipping, but only one, everything's developing. He mentioned clause 380, which is an exclusion. Early clause, that is no longer offered. It's been replaced by a clause which actually gives cover for what we call cyber risks. So the market is, this has been a huge shock to the insurance market. But the big advantage is the shock was felt more generally about 7, 8 years ago. So the markets have been well geared to the notion of cyber risks and the need to find insurance and what terms those insurance are. So as a maritime sector, we're going to benefit from that because we're coming in and at least there's a background. But also that tells us, I think, this subject isn't maritime. The insurance of cyber risks is broad. So that it'll be an issue of how we manage our insurances of the future. Because clearly, cyber risk is a non-maritime or non-marine risk. Nothing exceptional about that. In our policies, we have several non-marine risks that are being independent. But it might well be that for whatever reasons that I can't articulate, cyber risks is going to be seen as something significant. All major corporations want cyber risk insurance. Nobody acts without it. So it's a growing market. And we've got to see to what extent it comes in. All right. And also, it's not going to be cheap. Because worst case scenarios, I'm thinking about the Maersk incident about 7-8 years ago. Simple, on the news, it seemed quite simple. Cost Maersk about 300 million. Yes. That's serious money, even for a major corporation. So I think in the future, it might well be that ship owners to a degree will be thinking about cyber risk under a different policy. Obviously ship owners have their marine policies, but a range of other policies as it is. But cyber risks, might come in through a different route. Okay, now then, up. Thank you. A few introductory, my PowerPoints, I'll be quite frank with you again. I set them out in my ignorance, having already had a day and a half. I think I reformulate all my PowerPoints. But, you never cease being a student in this world. Right? So, as I've emphasized there, it's a non-marine risk. If we're talking about category 4, and I assume I'm going to follow the IMO categories without enunciating them on each and every occasion. That takes us into pure autonomy. Timescale, difficult to assess. I don't think it's going to happen tomorrow, but degrees of progress over time is very different. And of course, it has represented significant insurance challenges, as I'm already indicating. And as the earlier sessions I've emphasized, it's turned the marine world into a world, actually, because everything has been built up on the notion of a physical ship with a master and crew, and liabilities arising in association with the operation of that ship. Well, now we're into autonomous ships, possibly no crew, no master, external control, possibly totally internal control. And the prevailing problem, as again has been emphasized, is to what extent can we incorporate autonomous ships? And I think we're tending throughout to be speaking about the pure form, the category 4 in the main. Right? To what extent can we incorporate those ships into the established administrative, jurisdictional, and legal world which has been built up and which we call generally maritime law? It's quite a challenge. But it reminds me of something when I was a young man. And when I was really wet behind the ears, right? And something came in called hovercraft. Do you remember? Yes. We're too old. Some of you people out there wouldn't know what hovercraft is. But it's something that goes to sea, but it navigates on a cushion of air. And it was seen as the new world, right? So, our ferries going back and forth, going across, they're quite, and if you look at them, you still see them at kind of holiday resorts and the like. And God, is a hovercraft a ship? When have we heard that statement more recently? We had the same problem. But the world was a little simpler. So in the UK, I don't know how foreign countries dealt with them, but we had one statute titled hovercraft, and it went through the laws as they then existed and introduced hovercraft either absolutely or with qualification. So essentially, we say hovercraft is part of a family of ships. And but of course, nobody talks about hovercraft anymore. And I suppose some of the younger people here might not even know what I'm talking about. But there we are. So this is what's the historical, dilemma here. For the insurance industry is that there's no history. Like, a common lawyer without precedent is naked. What does he do? And the insurance industry is quite scientific in its way. It's not gambling, it's controlled gambling, it's intelligent gambling. They know the odds, and they're working on some kind of established quasi-scientific return of about 9-8%. So, the underwriters are engaged intelligently in assessing risks. You don't have that. There's nothing. You've got to just assess what you have to a degree. And of course, as the industry develops, that body of information is going to increase. But of course, the industry already knows that the worst case scenario can be very expensive. Maersk, 300 million, out of the blue, right? And that was picked up, rest assured. Well, without really knowing, I would be surprised if Maersk weren't to a degree at least insured. Because if you're not fully insured, it's interesting to be partly insured. So I think that is, but it's changing. Right, the London market, and I can only speak for the London market, right? It's this insurance sector is growing a pressure, a force from the corporate industry. And companies want it, and directors want it. They want to make sure that they're insured. And of course, they will have global insurance policies, which are quite comprehensive and which they can rely on. The other thing that the insurer has is my personal problem as well, understanding the technicalities. This is a complex world. Is it there for the super kids only? Who understands it? I don't understand how my smartphone works and my desktop computer. I couldn't be without them anymore. But if I have a problem, I lift up the telephone and I speak to my granddaughter, who sorts everything out. Like Susanna sorts me out here. Right? So, if you don't understand the technology, right, you don't understand necessarily the potential impact of a malfunction. Right? So, the insurers and underwriters are only human beings. It's also changed our notion of liability. Because when we had masters, ships, liability was personal injury, death, damage to cargo, a little bit of damage, hull damage and the like. But once we go into the world of the cyber, and we're already seeing it, in cyber insurance, what the commercial sectors, business interruption policy. They're more interested in the impact of their business from the damage to the ship. The damage to the ship, obviously important, but it could be smaller comment with business interruption. So just to give a simple example. And of vital importance, and several people have been talking about this directly or indirectly, is the application of the international regime to these ships. Now, not in the positive way that our chairman has been talking about, but with regard to the right to limitation. Now, that is crucial in insurance, because you take the right to limitation away and you will not get the insurance. And in any event, if you take it away from the statutes, it will be in the insurance policy. So, and when we come to P&I insurance, which I'll explain to you a little later, God, keep an eye on the time. I mean, but I'm still in the introduction.
Yeah.
So because P&I, which is such an important insurance for ship owners, which insures third-party liabilities, it's as comprehensive an insurance as you can think, and it's also as solid and as safe an insurance as you can think. Oh, right. That works on the basis that the club's liability is subject to the limitation in the statute, and that limitation applies even if you've lost the right to limitation under the convention, because there are always occasions where limitation can be lost. But that limitation stays with regard to the compensation, even if you can't. So you can imagine under a statute or under a convention, you could be liable for 100 million, and you can pick 75 million up only from your P&I club, which leaves a bit of a problem. So, that is, I think, for insurance generally, for reasons that I can, if these vessels that we're talking about, if they can't be brought into the international convention regime, trouble. Because I don't think your P&I, because P&I clubs are there to protect their members as well as to, because, and also I'll emphasize this, your insurer is in turn controlled by his reinsurer. So you take a club, you give them a what you might call a novel risk. When they scrutinize that, the most important scrutiny is the view of the reinsurer. Because all insurers lay off. Don't think that when you have an insurer who takes your hull for 100 million, that he is, which would not happen in any event, right? But if if they insure that, you'd get about 6 or 7 reinsurance contracts on that. And the reinsurer would insure again. So you have what we call retrocession. So you might start off with one underwriter on a hull, and when you've got a major, say, loss of the hull, and you're claiming, you've gone into a pool of about 45 underwriters. And that's how insurance survives. Spread the risk. Okay, where are we going here? Well, I'm not going to go through. This is the IMO category, right? And I know there are other categories, and I think there are many people here who think this isn't refined enough. I couldn't engage in that. The only thing I want to do, right, they're interpretive categories. But if you're an insurer, each category there has a different degree of risk. Each category there is significant. It changes visibly the management and navigation of the ship. But one is what we call a normal vessel today. But you take 2 and 3. 2 is a much better prospect ship to insure than 3, because 2 has the vital character that an underwriter looks for: recovery. If there's a problem, how can we effectively respond to that problem before it becomes a disaster? Now, if you've got crew on board, as you have under 2, you've got a master and crew, if I understand it properly, they're there. So the whole system can fail, but you've got your crew on board. 3, no. Big problem. And it's not only a problem, but one of the questions your insurer will ask you, if you had a 3 ship, what arrangements have you made to meet up with emergencies? So although they're not in the categorization of IMO, possibly you will have a condition in your insurance. So the insurer controls at the end of the day, what the law says, and all that is legal, all that is lawful. It's a lawful contract. And when you come to fully autonomous ships, well, after my time, probably. Oops. Oh, so thank you. Ooh, right on. I take them. I won't change it. Very quickly, what I've done here is to just itemize the kind of insurances your ship owner will have. Okay, the only ones I've learned to. So you see, there's quite a package. Of course, a lot of ship owners can't afford all that, right? Because insurance is a matter of what can I afford. Right? So you can have different degrees of risk category or coverage in each, right? But I think I have to speak again, Ego. Why not on me? I don't know what the audience there, but I will. The ones that I'm going to be talking about a little later are H&M, hull machinery, which is insuring the ship, and the P&I, which is third-party liabilities. And shipping is blessed. Probably one of the best third-party insurances. Now, what an insurer, shall I go to that? Okay, I have, okay. Now, what an insurer will want more than anything else is clarity. Now, you want clearness of thought and precision of definition. So don't go to an insurer and say, I want an insurance for cyber risks. Every time you read definition of cyber risks, there's a different word for it. Everybody does it differently. I had a friend who was in another world to me, but he talks about echo management. I think our chairman will know of that. And he said it so often, so long, and I think it probably was after the third or fourth whiskey. I said, you must tell me, what do you mean by it? And he followed it. You can be so familiar with something that you can't define it precisely. And that's my position as well. Yeah, but mine is more of ignorance and not anything else. So we when we're talking about, can I go back? I think, oh yeah, okay. Can I just check my? Yeah, I don't know what's happening here. I think, okay. So what I'm attempting to do here, and I'm not going to go into the details, but we have to come to a clear idea of what cyber is, right? Because we've seen it is, it's damage to the ship, it can be damage to the operation of the ship, but equally, it can be the incurring of third-party liabilities, and equally, it can be the product of malicious attacks. So there are all manner of different degrees. Now, rest assured, if you've got your insurance, cyber risks is going to be defined. And what we're seeing in the market currently, one of the crucial dividing points is malicious cyber attacks. That is being excluded. So you can have cyber attacks from within, cyber attacks even from without, as long as there's no malice. Because, some of these defects, these attacks are inevitable accidents. There's such a thing, born of negligence or intent, malice. Right? So the range of damage, and increasingly, as I've emphasized already, your ship owner is going to be concerned, yes, with the ship and his liabilities, but also with his commercial business interests. So the two buzz things of the London market is, business interruption. That's when an event affects the operation of the business and the loss of business. Okay, and also the other thing, reputational damage. That's almost taking us to the law of court, isn't it? The damage that can be done to a company today through the coverage in the newspapers, ask Maersk. So these things now, you are in a position to think about insurance. Right? But I think in the market, if you're in ships, I think there's no doubt that you are going to have cyber risks insurance with regard to the ship. But that is a bit narrow, isn't it? And it might mean that the maritime market sticks at that. And if you want your wider insurance, you go elsewhere for it. So you might find that the responsible ship owner of tomorrow will be dividing these kinds of risks between his maritime policy and the non-maritime policy. Because to repeat the point I made earlier, a maritime, a cyber risk is not instinctively and inclusively maritime. It's broad. And to repeat the point again, I think the maritime industry can benefit from that, right? Because cyber risk assurance is now available, but subject to the terms of the policy, right? And oh, here we are. Okay, so I've here summarized for you the kind of response of the insurance market. In a nutshell, a cautious response, and it's still new and experimental. So people are moving forward with great care. It's the London market has developed. It's surprising how much insurance is out there, right? And how much non-marine maritime insurance is out there, dealing with things like business interruption, reputation, and the like. The P&I world, well, as I think one of our speakers said, it's there to support its members. So they've got a group dealing with cyber risks, and the cover is there. What do you find, as I understand it, the P&I clubs are playing it a little coy. And again, I'm never quite sure because it's such a fast-moving area that you're totally up to date. But the general position is that if you have a loss within the rules, the fact that that loss is associated with the right cyber risk will not prevent your recovery. But provided is a loss within the rules, right? And of course, most losses in P&I relate to ships. So that isn't going to business interruption, right? It's probably where the London market is currently, or something similar. And then on the PowerPoint, you see ship owners is a P&I club based in London. They've recently come out with a policy, the Maritime Autonomous Vessel Liability Insurance. All risks policy. Covers war risks as well. It's there, but to who they will give the insurance, but it's there for members. I think it's being aimed initially at the kind of smaller ship area, but there is nothing. If somebody wants to read the policy, I have it with it somewhere. But there is nothing in it to indicate that it's restricted. So it shows you how the market is going. All right, it's going. But subject to the divisions that I've indicated. Now then, the conditions. And this is probably the most important slide I have. Because when I had the audacity to speak at the CFI conference, I mean, you were speaking there. I hope you didn't listen to me at all, because I did nothing but reveal my ignorance. But when I said this, the chief executive of the international group nodded, which gave me confidence. Go ahead. He said, ship to be flag state registered and to comply with all statutory requirements. Okay, but that is great. So in other words, we know that every ship, except for the dark fleet, right? Every ship is registered, has a flag. That gives it a status of authenticity. It means that the ship has been physically tested by class and is acceptable. But will an autonomous ship be registered? If it is not, you will not get the P&I. That is the first hill. So that's a challenge that some of you have been talking about. Okay. Classification. If you're not in class, join the dark fleet. And everybody knows what I mean by the dark fleet. These are essential. I think these are non-negotiable things. And the insurance that's coming out currently is for ships that are all in that category. Right? But what else to say? there are lots of standards out there, security standards, management standards coming from IMO, coming from classification societies, various other European and more international regulations. They could well be conditions to your insurance. So, your insurance company is going to want to make sure that your equipment, if I can use that loose term, is not only good, but constantly maintained. So if suddenly you have an accident and you've got old software, you've lost your cover. And also establishment of security management systems, because they're not going to give you this without you controlling it or being obliged to manage it effectively and well and safely. So I think the conditions are going to be very strict. And the final one is new for me, a pre-policy risk assessment. It's likely that when you come forward with a risk, you're actually going to have to, well, as you have to do for many of the codes that I've already mentioned, give an assessment or require somebody to give you a pre-insurance assessment of your electronic system and your management of it and the research techniques, how much training you give the operators. And what's interesting, the underwriter might even join in that. So if you're going for your insurance as part of the preliminary setting, you may have to meet up with the underwriters' representatives, right? But bear in mind, an early market, a slightly nervous market, a market not driven by 100% confidence. It's going to be very protective. And over time, as it becomes more familiar, and when we have data and we see precisely what the position is, possibly all these conditions. But bear in mind, the two top conditions apply to all insurance now. So it's not so revolutionary.
Now you've got 5 minutes.
Thank you. How do you get 3.5 hours in 5 minutes? Thank you. So obviously, I'm not going to get through. But I was going to, I think not particularly, I was going to go in to look at some of the covers in my later PowerPoints and see what adjustments and, master is there, crew is there.
But Rhidian, please have in mind that you will have a masterclass of 90 minutes. So everything you fit in here.
I thought the students. Oh, right. Well, people don't know. Right. Well, a question which is very often put, do we need new policy? Or can we amend the existing policy? Or how are we to go about it? Now, I'm quite clear, all the policies need a little bit of amendment if you operate with these policies, right, for reasons that I just thought, right? Because they're geared to traditional ships, masters, crew, and the like. And of course, they're great. That ties up with duties and liabilities as well. So I don't think it's impossible. And then, we go to the collision damage section of the cover as well. And of course, we're dealing about the world as it existed. So I think it would be possible, just if you had to be. But I think you'd also make quite a few amendments. It might be a little messy, but plenty of commercial contracts and underwriting policy can be messy, right? So it's not impossible. But I think I would favor something neater. In other words, I talk about hull policy. Well, there are about 40, 50 variations of it, dealing with different risks. So you could have a hull policy, brackets, autonomous ship cover, which essentially would give you the basic framework, right, of the existing HML. And also I'm talking now, obviously, about London forms, and there might be forms elsewhere, okay? But that would strike me as being a very neat way of doing it. Not possible. And of course, the downside of that, of course, is you were dealing with what you might call maritime risks. So that's going to give you cyber risk insurance to a degree only. Now, the other side, of course, you could come up with a cyber risks policy of a maritime nature. I mean, so I think what this is for the market to decide, and we can merely guess at the possibility. Now, I would favor the notion. I think if you look at cyber risk insurance now, there is clear division, maritime, commercial. And I would keep maritime insurance and contracts to the maritime sector, which means risks relating to the ship. That keeps the P&I clubs happy, it keeps the marine hull market happy, together with that variation of that. And that would mean that if our ship owner wants broader insurance to include things like business interruption, loss of reputation, repair of software or re-establish software, you go into the cyber risk section, which is specialist. Right? Now, there's nothing exceptional about that, because the ship owners already do that with different kinds of risks. And with a major ship owner, they probably have they would have a main policy with various sections, and the marine insurance section would be relevant to us, but the other sections would show that their interests are far wider. So I do increasingly think that this is going to be a specialist market, very specialist. The insurers will come up to speed with it. They no doubt taking advice and learning from experience. And I would say ship owners, let's stay where we're familiar. And then when you want this wider policy, go to that section of the market. And of course, the London market is only one option. The standard reforms available in the London market, one option. Insurance, unlike other areas of maritime, is not subject to an international convention as to substance or jurisdiction or practice. Right? So there's a huge amount of choice. But of course, a lot of insurance is done on what you might call the London forms, subject to English law. That's the question of choice. Okay, and even if you go for another jurisdiction and another choice of law, very often, in my experience, you use London forms as the basis of your insurance, which I'm not sure is the safest way of doing things in life.
I'll give you another 5 minutes.
we have a very tolerant chairman here, and I think I've finished my time. Thank you for your attention, and hopefully I've said something of use to you all. Thank you.